Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just the YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mishegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. A cupcake sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Guess who was bored today? Thank you to my amazing viewer, Melissa, who made that song for me too long ago. And I just never got around to making a video to go with it. And how cool is that? Do you like it? Do you like it? So in between the two other streams that I did today and right now, I just threw together a video on Canva, put it to music and said, I'm just going to throw it out there and see what you guys think. How cool is that? Wasn't that awesome? Oh my God, Melissa, you're amazing. I don't know if you're here today, but I don't want to give out your whole name because, not everybody wants their public details on the interwebs of YouTube and such, but I love it. And I think it's really cool. She made me two different versions even. One was this one that I liked better was a reggae one. And the other one was a more kind of a soft rock version. So thank you, Melissa, for your amazing, amazing work. I don't know how you did that, but you did an amazing job, and I appreciate it so much. What the Duckling is here for live number 3 today. Live number 3. I'm a mess. I need a nap, but I'm here for you guys. This morning we did the Boss Baby, Robert Tellis's sentencing. Then we did the live Menendez Brothers press conference with Mark Garagos, and now somebody sent me the ACLU brief that was filed today with the SJC in the Karen Reed appeal. So we're here for it. The American Civil Liberties Union apparently seems to think that the civil liberties are at risk in Norfolk, Massachusetts. IYKYK. So thanks, What the Duckling has been here for all 3 and being here for it and for your 10. And thank you, AA, for becoming a new YouTube member. And to Stacy Face Travels, thank you for the 10. Who says I'm the best. Loved you last night. Thanks for all you did. Was that only last night? Feels like a week ago. But I did get a clip of that in the intro today. So yeah, it actually was yesterday, last night. If you haven't seen it, it was a really good show, in my opinion. Go back and watch it. Mama She, you're the best. Says, yay, love the intro. Thanks for hanging around with me for 2 months. Sherry D, thank you. Love the new intro. Thank you, Sherry D. Thank you so very much. Did anybody notice that there's a picture in there of me and John Ray? You know John Ray, the Long Island attorney who's been representing the family of Shannon Gilbert for so many years. And one day when I was going to see the Long Island serial killer in court, I ran into John Ray. Actually, no, it was during a Jimmy Burke hearing. Jimmy Burke, what used to be the chief of police out here. We had a lot of corruption on Long Island in Suffolk County. He went to jail along with our district attorney, Tom Spoda, who is still sitting in federal prison. But anyway, John Ray is a local guy who wears the most amazing outfits. And I was like, we got to take a picture together. So we did. So thank you. Thank you for loving it. Thank you, Sherry, for your 10. Oh, Yuri's math teacher coming in with not only 5, but 10 memberships. Thank you, Yuri's math teacher. So kind and generous to all of us creators here on YouTube who have become fast friends due to the craziness that we're all going through together. I don't think anybody can understand what you're going through as a YouTube creator, other than other YouTube creators that are also covering the same crazy, wacky stories that we are. So thank you so very much to Yuri's math teacher. Grandma Quack is in the house, says, let's go ACLU. Let's go, good citizen. Oh my gosh, that is great. I love it. Look at the little profile pic for good citizen. It is a rubber ducky dressed like a grandma. I am here for it. I'm loving it. You guys really are the most amazing, most generous, and most kind chat on all of YouTube. I really, really believe it. And I really, and look, Team Brittany, again, Team Brittany, put your phone down. Walk away from your phone. She's already gifted like between last night and today, like 50 memberships. So thank you, Team Brittany, who's an amazing, amazing moderator. And also such a very kind and generous human that I love with all of my heart. And hi, Alex. If you're watching today, Alex is also a mod. I think she's, how old is Alex? 5 or 6? And she's learning and she's liking it here. So Alex, we love you. We're very proud of you. Pilgrim shout out. Thanks for the 10. Happy birthday, Bob Weir and John Mayer. Is today their birthday? How did I forget? Seems like all this life was just a dream. Happy birthday, Bob Weir and John Mayer. Isn't it crazy that they both have the same birthday? And that they're both like in a band together? Well, kind of. And also, did you see that in my intro too? I had to put in some footage from the Sphere and also the outside of the Forum, which is one of my favorite venues, aside from Red Rocks, the Hollywood Bowl, and Madison Square Garden. Just Ducky, you're always ready to keep us in the know. I try. I'm here for you. You guys said, can you do it? I said, okay, I got to read it. You guys said, no, you could just read it with us. And I said, okay, I'm going to try and put on my best ASMR voice so that you can, listen to this later on the replay. And if you want me to put you to sleep. Virginia Little has been here a lot longer than 2 months. Maybe lurked too much. I don't think so. I recognize your name. No relation, but so happy to have you here. Christine, thank you for the 5 super sticker. Redine for the 10. You guys are coming in hot tonight, coming in hot. And Sherry for gifting a membership. Thank you so very much. Well, the ACLU is getting in on the game, you guys. They're getting in on the game. They have filed a brief. We're going to look at it together. And who knows what could happen? Who knows? But before we get to that, there's an article in the Boston Globe, and this was just published a little bit earlier today. And I will read that to you because for so many of you, the Boston Globe is behind a paywall. So, I'm here to help. I drop what I'm doing. I come, I hang with you guys because you guys are always there for me. So I'm always there for you. Here's the Boston Globe article from this afternoon. The American Civil Liberties Union is joining with Karen Reed in her appeal to the state's highest court, arguing in a new file Wednesday, that's today, Bob Weir and John Mayer's birthday, by the way, October 16th, that the judge in Reed's murder case declared a mistrial too quickly and failed to take the appropriate steps to ensure that she's protected against double jeopardy. The filing by the Civil Liberties Group, back to 1. The filing in the Civil Liberty Group's chapter in Massachusetts comes as the Supreme Judicial Court, or SJC, prepares to hear arguments about the results of a trial that captured local and national headlines for months earlier this year. I'm going to also go so far as to say international, and to all my international viewers in the chat, say hello and tell us where you're watching from, because this has become, in large part, to not only Aiden Carty, but so many other people who are covering this in the streets of YouTube. This has become an international story. Look at that, Finland, Kooky Carolinian. Kooky Carolinian is in Finland. She's here for it. The world is watching, my friends. The world is watching. Reed, 44, was charged with killing her boyfriend, Boston police officer John O'Keefe, in January 2022 by drunkenly hitting him with a car and leaving him to die in a snowstorm outside the home of a fellow Boston police officer. But her lawyers argued that she was framed as part of a law enforcement conspiracy and that O'Keefe was actually beaten by people at a gathering inside the home and bitten by the family dog there before his body was dumped on the front lawn. Not the dog's body, Officer John O'Keefe's body. Superior Court Judge Beverly Canone declared a mistrial July 1st after jurors reported that they were deadlocked. Prosecutors immediately said they would retry the case. But then multiple jurors contacted both the prosecution and defense teams post-trial, saying that they actually were only deadlocked on one charge, manslaughter by operating under the influence. The jurors said that they had all agreed she was not guilty of the other two charges, murder and leaving the scene of a crash with injury. Reed's lawyers asked Canone to have those charges thrown out. Oh, she's not going to be happy to see that they spelled her name wrong. In the Boston Globe, they wrote Cannon, not Canone. We know it's Canone. If she would not, they argued, then she should hold a hearing and call back jurors to explain what happened during their deliberations. But Canone rejected the request. I don't know why I'm hearing that when I have my do not disturb on, but nonetheless. Reed's team appealed, arguing that she would be subjected to double jeopardy if she's tried on the two charges again. The retrial is scheduled for January, and the arguments before the SJC are slated for November 6th, and we will be covering that live. It will be broadcast. We will cover that live together. Not missing that. In the court filing Wednesday, the ACLU supported Reed's argument that she would be subjected to double jeopardy by being tried for the same charge twice. Quote, a retrial on acquitted charges would violate the prohibitions against double jeopardy, a critical right enshrined in the Fifth Amendment to the United States Constitution and Massachusetts common law, states the court filing. The filing is an amicus brief, meaning it's filed by a third party that seeks to weigh in on the case. The ACLU focused on whether Canone should have held an evidentiary hearing after the jurors came forward. Quote, the trial court had a clear path to avoid an erroneous mistrial, simply asked the jurors to confirm whether a verdict had been reached on any count. Asking those questions before declaring a mistrial is permitted, even encouraged by Massachusetts rules, the ACLU wrote. I'm feeling so validated right now. Daniel McFadden, managing attorney for the ACLU of Massachusetts, said in a statement that the organization is seeking to highlight serious constitutional concerns about the trial court's process. Our core concern is what occurs when a viable question is raised regarding the outcome of the jury's deliberations and what processes will be employed by trial courts addressing similar circumstances in the future, he said. That is the Boston Globe article from just this afternoon. Huge, huge. Gregor Smith, this is huge. Midnight, where are you, Kristen? Okay. Yeah. All the years combined, they melt into a cream-filled cupcake. I see what you did there, Phoebe Bird. With the Grateful Dead lyrics. If you know, you know. All right. Misspelled for a reason. Judge Cannon. They all do that to hide the person for future reference. Just saying. Oh, yeah. Oh, yeah. Remember that as such, Michael Proctor spelled a lot of name wrongs in the witness statements because, it'd be harder to find them. Maybe. As did some of the other troopers and police and PDs. Thank you so much, Sarah, for thanking me for all that I do and for sending me a Venmo. An angel or Angel. You are quite an angel. Thank you so much also for your Venmo. You guys are really my favorites. Don't tell the others. All right, let's get to it. We've got a lot to read. And in my best ASMR voice, here we go. This is what they call an amicus curiae brief or friend of the court brief. This is when a party who is not a party to the case wants to weigh in and give their thoughts. And they do this without charge in cases, especially the ACLU, in cases where they feel very, very strongly that someone's civil rights are being violated and that it is of utmost importance that they weigh in. I'm here for it. I agree. I know all of you are here for it too. It's like having an extra member of the team, right? That Karen doesn't have to pay for. So there's that. Thank you, Christine, for your super sticker. Thank you, Charlene, for loving me in the glare and for your super sticker. Thank you to Della for saying Alan Dershowitz should be representing it so bad. Agreed. And Team Brittany again, coming in with more memberships. If you don't stop, I'm going to have to take your phone away and I'm going to have to shut off the fan. Really, I'm not even kidding you. Please. All right, let's go. I have to make this bigger, so it's probably helpful if you would save your questions for the end so that I will see them, because if you're in chat asking questions, I will not really see them right now. As we have discussed many, many, many times, appellate work is very different than regular trial lawyering. It is a specialty. It involves a lot of writing, a lot of research, and you have to be able to argue on your feet in front of what this is going to be a whole panel in Massachusetts, not just one judge. It's a panel of judges in the SJC. They are submitting this to the full panel. I think there's 6 judges, I think. Don't quote me on that. You can correct me if I'm wrong in the chat. You also have to be able to think on your feet. You have to be able to answer questions, because the judges can ask you questions during your argument, and they will. So you better know all the case law backwards and forwards. It is not something that I would excel at, appellate lawyering, but it is something that some people are very, very good at. And so typically you hire an appellate firm or an appellate attorney like Marty Weinberg to come in and handle the appeal on your case, because it is a very different style of lawyering. And printing as well, because you have to print in a certain font, you have to print in a certain color, you have to print, you're limited to a number of pages, you have to have a table of authorities. I mean, this is like serious work. And appellate printers also make a lot of money, because it's very expensive to get your briefs printed up in the proper form to be able to submit to the appellate court. Some of you may have noticed, if you were following the appellate court docket, that it said something like, and don't quote me because I don't have the exact color, but it said something like, red brief has been filed, waiting for the blue brief. And now this ACLU brief is in, but it has not hit the public docket yet. But, I have sources. Thanks, Melinda, for sending this to me. And it's very, very, there's a format that has to be followed. Here's the table of all the cases that the ACLU is citing. I mean, look at all of these cases. And then they have a list, a table of all the constitutions, statutes, and rules that they are also citing as authority for their position. And then some publications, some other authorities that they're going to rely on here about the Fifth Amendment. Look at this, something from 1680. Institutes on the Laws of England from the year 1680. And then there's some other learned treatises, as it were, regarding a history of double jeopardy from 1963, constitutional law, and some commentaries. Very interesting. All right. Corporate disclosure and Rule 17C5 statement. Yeah. 30 pages about why Bev should kick rocks. Says, even my mics are hot, which is one of my favorite screen names ever. All right. Try not to distract me. I'm gonna turn the chat off for a second so I don't get distracted, because my ADHD is everywhere today. Pursuant to Supreme Judicial Court Rule 1:21, the American Civil Liberties Union of Massachusetts, Inc., ACLU-M, is a nonprofit organization or corporation organized under the laws of Massachusetts. ACLU-M does not issue any stock or have any parent corporation, and no publicly held corporation owns stock in ACLU-M. No party or party's counsel authored the brief in whole or in part. No party, party's counsel, or any other person or entity other than ACLU-M, its members, or its counsel contributed money that was intended to fund the preparation or submission of the brief. ACLU-M and its counsel do not represent and have not represented one of the parties to the present appeal in another proceeding involving similar issues, and were not parties in and did not represent a party in a proceeding or legal transaction that is at issue in the present appeal. In other words, we are wholly and completely separated from all the parties in this case. We have nothing to do with this case. Nobody's paying us for our opinions. Nobody paid us to do this. We are here on behalf of the people of Massachusetts and the people of the United States of America. We speak for them. We are not hired or paid for by anyone. We are not even a for-profit organization. We are not for profit. We just believe in this so strongly that we're here to give you our friendly opinion and brief on what we think, SJC, you should do. Footnote 1 says, prior to seeking leave to file this brief, ACLUM asked counsel for Ms. Reed and the Commonwealth whether they would assent to or oppose the ACLUM's motion to file this brief. Appellant's counsel assented, and the Commonwealth took no position. Of course, they took no position. So, in other words, both sides, well, one didn't, just took no position. And Karen Reed's counsel said, sure, file it. Of course, we agree to let you. Next section is entitled Interests of Amicus Curiae. ACLUM is the Massachusetts affiliate of the National American Civil Liberties Union. ACLUM is dedicated to protecting and advancing the civil rights and civil liberties of all the people in the Commonwealth, including those guaranteed by the Constitution and the Bill of Rights. ACLUM frequently engages in litigation and other advocacy to protect the rights of people involved in the criminal legal system. As part of that work, ACLUM has filed many amicus briefs before the Supreme Judicial Court. C, for example, e.g. means for example, in case you didn't know. I love to teach Latin while we're going through this class. For example, brief for American Civil Liberties Union of Massachusetts et al. As amici curiae, and then citing some other cases here that we don't need to read through, but I will leave this on the screen in case you are so inclined to actually go up and look at these cases yourself. All you need to do is Google the case name or the citation, and you too can read these cases for yourself. It's unfortunate, I think, just to break from this for a second, that they don't teach Latin in schools anymore, because I took Latin, I think, in junior high, and it really helped me with my vocabulary and so many other things. I really think Latin should be brought back. Just because it's a dead language doesn't mean our kids shouldn't have to learn it. Look, they're not teaching these kids handwriting right now. So you think the penmanship is so terrible? Teach them Latin, teach them something. All right, thanks anyway. Welcome to coming to my TED Talk. Here, ACLUM takes no position on what the evidence presented at trial did or did not show. Rather, this brief addresses the trial court's decision not to respond to compelling evidence that there was a potential mistake or misunderstanding concerning the outcome of the jury's deliberations and what processes will be employed by trial courts addressing any similar circumstances in the future. Introduction and summary of argument. Defendant appellant Karen Reed faces the possibility of being retried on her multiple criminal charges for which numerous jurors now say or claim they acquitted her. A retrial on acquitted charges would violate the prohibition against double jeopardy, a critical right enshrined in the Fifth Amendment to the United States Constitution and the Massachusetts Common Law. If the court does not grant appellant's requested relief to dismiss or otherwise preclude the counts on the current record, then this court can and should prevent the potential for injustice by ordering the trial court to conduct an evidentiary hearing and determine whether the jury in her first trial agreed to acquit her on any count, such that it was not manifestly necessary for the trial court to declare a full mistrial. This brief provides the court with additional context regarding the justifications for an evidentiary hearing into a lack of manifest necessity. At appellant's first trial, the court declared a mistrial on all three counts after receiving notes indicating jurors were struggling to reach a unanimous verdict. But the court did so without polling jurors to confirm they were deadlocked on all counts, or even asking the parties whether they consented to a mistrial or wanted the jurors polled. Soon after that hasty mistrial declaration, multiple jurors reported that the jury had actually agreed to acquit appellant on counts 1 and 3, and so were only deadlocked on count 2. Appellant promptly moved the trial court to either dismiss counts 1 and 3 or, at a minimum, conduct a post-verdict evidentiary hearing to assess the truth of the jurors' reports. But the trial court denied the motion to dismiss and refused to conduct a hearing, leaving open the possibility of appellant being retried in violation of her right to be free from double jeopardy. Somebody put in the chat, Karen's Law. Oh, somebody tell Kathleen McCarthy what ASMR is, because I don't really know what it stands for, but I just know what it is. The trial court erred in refusing to conduct an evidentiary hearing. The double jeopardy clause protects a defendant's fundamental right against successive prosecutions for the same offense. That right is deeply rooted in our nation's history and legal system and has been vigorously enforced by both the United States Supreme Court and this court. To avoid improper successive prosecutions, the double jeopardy clause requires that courts carefully consider alternatives to declaring a mistrial and to make such a declaration only after finding a mistrial to be a manifest necessity. A failure to do so can bar reprosecution on double jeopardy grounds. We talked a lot about manifest necessity and whether it existed to declare that mistrial. The court had a clear path to avoid an erroneous mistrial, simply asked the jurors to confirm whether a verdict had been reached on any count. It's like somebody's listening to me. Asking those questions before declaring a mistrial is permitted, even encouraged by Massachusetts rules. Such polling serves to ensure a jury's views are accurately conveyed to the court, the parties, and the community, and that defendants' related trial rights are secure. It is also consistent with a nationwide practice of polling juries to ascertain verdicts, including before declaration of a mistrial. Here, a post-trial evidentiary hearing would serve the same purposes, enabling the trial court to determine whether the jurors had actually agreed to acquit appellant on counts 1 and or 3, such that it was not manifestly necessary for the court to declare a full mistrial. Accordingly, an evidentiary hearing is required to safeguard appellant's rights under the double jeopardy clause, and the court should order the trial court to conduct one. It's like the voice of reason has entered the chat. Point Roman 1. The prohibition against double jeopardy is a fundamental constitutional right that protects against the burden of multiple prosecutions. The double jeopardy clause of the Fifth Amendment provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. Footnote 2. The double jeopardy clause has been incorporated against the states through the 14th Amendment. See Benton v. Maryland. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Thus, the double jeopardy clause exists to ensure that the government, with all its resources and power, is not allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity. I mean, if this is not a continuing state of anxiety and insecurity, my friends, I don't know what is. And not only for Karen Reed, for every single one of us who's been following this case. And it feels like we have run into brick wall after brick wall after brick wall because we're being gaslit. We're being gaslit into believing that what's going on here is, number one, not a cover-up, but number two, constitutional in some way. It's like permanently living in the Twilight Zone. Let's see some Twilight emojis in the chat. Twilight Zone emojis. We are outraged. We've got that emoji too. Don't worry. We are outraged because we've been gaslit into thinking that this is somehow okay. And it's not okay. It's not okay. We've been gaslit into thinking Massachusetts rules do not permit a judge to poll the jury. This is the ACLU of Massachusetts, okay? This is what they do. This is what they do. And they do it very well. Citing Green versus United States. The historical roots of the double jeopardy clause long predate the American founding. Its origins can be traced to Greek and Roman times, and it became established in the common law of England long before this nation's independence. Citing a 1959 case. fear and abhorrence of governmental power to try people twice for the same conduct is one of the oldest ideas found in Western civilization. In medieval times, canon law prohibited double jeopardy on the basis that God does not punish twice for the same transgression. Citing a paper by J. Sigler, A History of Double Jeopardy from 1963. And as early as the 15th century, the English courts had begun to use the term jeopardy in connection with the principle against multiple trials. See US v. Wilson, 1975. This thread continued through Sir Edward Coke's 17th century treatise on the laws of England, which articulated a theory of double jeopardy. And that goes back to 1680. And that was in 1680, that was the 6th edition. When were the other editions written? In the 1500s? I mean, that's how old this principle is, my friends. And in his 1769 commentaries, Sir William Blackstone famously wrote of the universal maxim that no man is to be brought into jeopardy of his life more than once for the same offense. Concerns about double jeopardy crossed the Atlantic with early American colonialists. In fact, the American conceptualization of double jeopardy began with the Massachusetts colony. It's the birthplace. Massachusetts is the birthplace of double jeopardy in America. Praise be the ACLU. The 1641 Body of Liberties provided for an expansive prohibition against double jeopardy that extended to criminal and civil offenses. See the Massachusetts Body of Liberties, Article 42 from 1641. This provision was mirrored and extended in the Massachusetts Code of 1648, which required the express recording of past legal actions to prevent future jeopardy. That's right. That's right, Al Salt. Hold on. This deserves highlighting. Coming back. Oh my God, that's just painful. Double jeopardy literally started and ended in Massachusetts. Yep. Anthony's just like, wow. Bev is like, Justice who? Says Sue Sampson. I'm shocked, says not a surprise. I'm shocked is not shocked. Massachusetts has shown us that they have zero respect for the Constitution. Nancy says, remember when Melanie would do members only on the full moons? Yeah, we got it. There's one coming, right? Like soon. I gotta love a gal that just gets it. Happy to be here with you. Happy to be here with you too. I'm feeling the release from the full moon already. Thank you, Handmaid's Tale. Praise be. That is exactly where it comes from. If you know, you know. Praise be. Under his eye, blessed be the fruit. It's like almost coming true. Handmaid's Tale. It was so creepy. For those of you who haven't watched it, highly recommend. Exactly, Sir Winston Squeakerson. The reason there's not too many cases that are new on this is because of how utterly fundamental this is. Thank you, thank you, thank you. You get it. You get it. You understand me. You get me. I'm a constitutionalist. These found, let's see. This provision was mirrored and extended in the Massachusetts Code of 1648, which required the express recording of past legal actions to prevent future jeopardy. Citing a treatise or paper called A Brief History of the Fifth Amendment Guarantee Against Double Jeopardy from 2005. If any of you are interested, I'm sure that's probably a great read. These foundational tenets of Massachusetts law arguably shaped the nation's subsequent adoption of the Double Jeopardy Clause in the Fifth Amendment. Okay, so Massachusetts law predates the Fifth Amendment to the US Constitution. That's how rooted in Massachusetts specifically, the double jeopardy foundational tenets are rooted in your state, my friends. While enactment of the Double Jeopardy Clause was relatively uneventful, early American jurists quickly recognized its importance. An 1824 Kentucky Supreme Court opinion referred to the prohibition on double jeopardy as a wise rule, so favorable and necessary to the liberty of the citizens. An 1833 decision by the New Jersey Supreme Court observed that this great principle forms one of the strongest bulwarks of liberty. There's a word you don't see much, huh? Bulwarks. State v. Cooper, 1833. And in 1834, Justice Joseph Story called the double jeopardy clause a constitutional recognition of that fundamental rule of the common law, which has been recognized by elementary writers and courts of justice from a very early period down to the present times. Citing a Massachusetts case from 1834. See also Joseph Story, a familiar exposition of the Constitution of the United States from 1840. Listing the double jeopardy clause as a provision enacted to secure the great palladium of liberty, the trial by jury in criminal cases from all possibility of abuse. Oh, we know abuse. We've been suffering abuse since we started covering this case. I started covering this case in January of last year. It's only been not even 10 months that I've been covering this case, and I feel abused. We need to secure the great palladium of liberty, my friends. That's why we're here. That's why I'm talking about it. That's why I let them trash me all over the internet for talking about it, because that's what we're doing. We're just trying to secure the great palladium of liberty over here. It's a noble cause, and somebody's got to fight it. So that's what we're doing. In modern times, the Supreme Court has recognized the fundamental import of the Double Jeopardy Clause by expanding its scope. Notwithstanding the text of the Fifth Amendment, double jeopardy protection extends to all crimes, capital or otherwise, citing a case from 1873. And the existence of an acquittal is of federal, not state law, with a constitutional floor that prevents the states from impeding a defendant's double jeopardy rights. See this? The existence of an acquittal is a question of federal, not state law, with a constitutional floor that prevents the states from impeding a defendant's double jeopardy rights. Just might be, well, we haven't gotten there yet, but it could be. We're only halfway through the most important sentence of this entire brief. Jeopardy also attaches when a jury is impaneled and sworn in, not when a verdict has been given. That's a 1978 case. Finally, as relevant to this case, the Double Jeopardy Clause can bar retrial even when the first trial ends in a mistrial with no acquittal or conviction. Okay, that's let me put on my highlighter because I haven't read this yet. This is a cold read for me and you, but we need to highlight the pertinent portions, and that is a pertinent portion. For even if the first trial is not completed, a second prosecution may be grossly unfair and burdensome to the defendant. Well, it sure is burdensome. Sure is costing a lot of money. For the defendant, Karen Reed. Moreover, the defendant has a valued right to have his trial completed by a particular tribunal or chosen jury, such that the only showing of manifest necessity, back to one, such that only the showing of manifest necessity will allow a trial court to declare a mistrial without barring a retrial on double jeopardy grounds. Citing Wade, quoting U.S. v. Perez, 1824. That's how deeply, 1824. The decision to declare a mistrial without a defendant's consent is only justified by a high degree of necessity and requires a scrupulous exercise of judicial discretion. In Massachusetts, where there is no specific constitutional protection against double jeopardy, but where the common law protection thereof may be greater than either the state or the federal constitution requires. The declaration of a mistrial requires the trial court to both, one, provide defendant's counsel with a full opportunity to be heard, and two, carefully consider alternatives to a mistrial. I'm going to break from this to say that you and I both know neither of these things was done. Neither was done in the case of Karen Reed. Judge Canoni said, yeah, I'm not going to do that to you. I'm going to declare mistrial. You don't have to go back. Thank you very much. Goodbye. Did not allow Karen's attorneys to be heard. Just because she allowed them to be heard during the prior note that the jury brought in, that doesn't carry over. She did not carefully consider any alternatives to a mistrial, including consulting with the attorneys, including allowing the attorneys to consult with their client, the defendant, Karen Reed, about whether or not she, in fact, would consent to a mistrial. These are basic fundamental rights that the United States guarantees us under our Constitution. That's why people say that we have the greatest justice system in the world. I hate to see it crumbling before our very eyes. Together, the above sources sing a simple but powerful melody regarding the importance of the right against double jeopardy in criminal proceedings, which is deeply ingrained in the Anglo-American system of jurisprudence and bolstered by recent precedent. I love this. They sing a simple but powerful melody. This brief is like music to my ears. Accordingly, when the government asserts the power to retry a defendant who has already gone through the burdens of one full trial, as is the case here, courts must safeguard the defendant's fundamental rights by carefully scrutinizing that assertion in light of all the available information. Roman 2. Trial courts regularly poll juries before and after a verdict is announced. Wait a second. It looks like there's a word missing there. Trial court. Okay. Trial courts regularly poll juries both after a verdict is announced and before a mistrial is declared. In her motion to dismiss, appellant asked for a post-verdict evidentiary hearing to determine whether the jury had agreed to acquit her on counts 1 and 3. The Commonwealth opposed this request as improper, and the trial court rejected it as prohibited, in quotes. But the propriety and sometimes necessity of inquiring about the outcome of a jury's deliberations is confirmed by the fact that trial courts regularly poll juries on verdict-related issues. Massachusetts courts frequently poll juries to determine whether the announced verdict was correct. They do. You've seen it. Juror number 1, is that your verdict? Yes. Juror number 2, is that your verdict? Yes. Juror number 3, is that your verdict? Yes. Juror number 4, is that your verdict? God save the Commonwealth. Consistent with Massachusetts procedural rules, courts in this state and others also poll juries to determine whether deadlock exists or if future deliberations would be useful. She didn't want to do that either. Massachusetts Guide to Evidence, Section 606B and Rule of Criminal Procedure, both 27D, both allow the court to poll juries after a verdict has been returned. Granted, it is within the trial judge's discretion whether to poll the jury. But there are times when a judge should use the discretion accorded by Massachusetts law to poll a jury after the verdict is returned. So what they're saying is, just because you have the discretion not to, doesn't mean you shouldn't. For example, in Commonwealth versus Nettis, the trial court properly conducted a poll of the jury when one juror indicated her disapproval of the announced verdict. As with the evidentiary hearings discussed above, the court's polling of juror votes does not impermissibly intrude into the jury's deliberative process. See Commonwealth v. Span. I'm going to pause for a second to go to the chat And also to ask everyone to smash the like button so I don't have to turn off the air conditioning. There's 3,000, almost 3,200 people in here, which is a fantastic crowd for dinner time on a Wednesday worldwide. Well, it's dinner time on the East Coast anyway. I'm sorry. Buzzing for truth. Melanie, what does that mean in our layman's terms? I'm not sure what you're this is from about almost a half hour ago, so I'm not sure what you're asking. But hopefully your question's been clarified a little bit by what I've been reading. Means you can't be tried twice for the same crime. That is against not only the Constitution of the United States of America, but it is rooted in such deep Massachusetts law that it goes all the way back to the 1600s. Sue Candell, I'm confused. ACLU, liberals usually left politically. Massachusetts is a very blue. Thus, power is blue, and so is the corruption. How to clean it up? I don't know what you're asking me, but the ACLU is all about the Constitution and constitutional rights and civil rights. And I don't think this is a political issue. I think this is a constitutional issue. So I'm not even going to go into like, the parties and this is an election year and, red state, blue state, red fish, blue fish, one fish, two fish, red fish, blue fish. This is about the Constitution of the United States of America. I don't care what side of the political aisle you're on. I don't care what kind of state you live in. I don't care if you're a liberal or a conservative. This should matter to everybody. How to clean it up? No idea, Sue. I'm just glad I don't live in Massachusetts. Just Ducky, was this expected or a surprise? Oftentimes, ACLU and others, there may be other organizations that may file amicus curiae briefs. It is a happy surprise. It is a happy surprise. I did not know that they were going to file this. I do not know. Well, they asked the Commonwealth and Karen's attorneys if they would approve, so they wouldn't have to make a motion. And based on the fact that Karen Reed's attorneys agreed and Lally just had no position, it's going to be allowed. The briefs were due today. Today was the day for the brief. So I haven't seen the Commonwealth's brief yet, but when I see it, we'll probably do that tomorrow. Polly Claire, thank you for becoming a YouTube member. Love ya. Nikki, thank you for the 20. Says, I'm a rock star. Karen is actually innocent. Yeah, actually innocent. Like when people say she's factually innocent, like what does that even mean? Factually innocent. John O'Keefe was not hit by a car. Karen Reed's car did not hit John O'Keefe. Therefore, Karen Reed is actually innocent, in my opinion, according to the evidence, the physics, the testimony of, the biomechanical engineers hired by the FBI. Hi, Jilly Bean. Curious what this can actually do for Karen. They're putting, they're going to garner a lot of attention with this filing worldwide because you guys are here for it. You guys are worldwide, even though it's the middle of the night for you over there in Finland and Norway and South Africa. And it's tomorrow in Australia, and you guys are watching. So it's going to shine a much needed spotlight on this case, on Massachusetts. This panel of appellate judges, this is the highest court in Massachusetts. They take their jobs very, very seriously. The next step from maybe going from the SJC of Massachusetts is maybe going up to a federal court, maybe going to the U.S. Supreme Court. I mean, these are very learned judges that sit on the appellate courts. And they also take the Constitution very seriously. So it always helps to have another impartial, well, not impartial, but another party on your side that you're not paying, like the FBI hired accident reconstructionist biomechanical engineers that testified at the trial. Oh, I'm glad you caught me, Beverly. I'm glad you caught me too. Thank you. Thank you so much. SJC has not recorded the Commonwealth's response timestamp as of 1:20 p.m. today. Thank you so much, Suze. I just checked before I came on as well to see if it did, if it was filed, but it was not. But if anybody gets a hold of it at any point, you can always feel free to email it to me. I read all your emails. I can't always respond, but appreciate the collaborative nature of this channel as always. Moving on. Federal trial courts have also polled juries to determine whether they are truly deadlocked ahead of a mistrial declaration. Something else she did not do. And now they're talking about federal courts. And look, federal courts are usually a little more highly regarded than state courts. You know, a lot of times, like a Massachusetts judge may not want to hear about cases from other states, and they may not want to hear about federal cases because that's not the way that we do that things in Massachusetts, Mr. Jackson. It's not the way we do things in Massachusetts, Mr. Jackson. We stand in Massachusetts, Ms. Little. Is something funny, Ms. Reed? But the appellate courts and the federal courts care. Federal trial courts have also polled juries to determine whether they are truly deadlocked ahead of a mistrial declaration. In the United States v. Barbioni, the jury deliberated for 10 hours but could not reach a verdict. Before declaring a mistrial, the district court polled each juror individually and with great care. All stated that the jury was deadlocked and not likely to reach a verdict. On appeal, the First Circuit found these actions supported by manifest necessity for a retrial. Many other federal courts have also polled individual jurors to ask whether a deadlock exists before declaring a mistrial. State trial courts have likewise polled jurors ahead of a mistrial declarations in order to determine whether manifest necessity exists. In State v. Gendreau, which is a case out of Maine from 2017, the jury sent 3 notes that indicated potential deadlock. The trial court individually polled the jurors after each note to determine whether deadlock truly existed. On appeal, the Maine Supreme Court characterized this effort as thorough and appropriate to determining whether a mistrial was manifestly necessary. Other state courts have exercised similar care to thoroughly assess whether a mistrial was necessary. And there's a whole lot of cases cited after that. This kind of pretrial, and then there's a footnote 3. We like the footnotes the best. Some courts have gone even further. Now, see, this is where all the nuggets are. For example, in Halverson, the jury was potentially deadlocked on the punishment for 1 count. After asking the jurors whether additional deliberation would be useful, the trial court specifically asked where the jury was leaning numerically. That is something that is often not done, but they're saying, yeah, some courts have gone even further. The California Supreme Court concluded that the judge's actions supported his later declaration of a mistrial. Sometimes if the case law does not exist in your state because, never came up before, you got to look to other states and you got to look to federal cases and you got to look elsewhere. You got to be willing to dig a little deeper and do a little investigation as to why perhaps maybe you should not be so hesitant to make new law and just do the right thing and do what the Constitution of the United States of America and Massachusetts requires. Have the cojones to do it. Thank you, Suzanne, for the Cash App. You are very sweet. Thank you very much. Okay. So there's some breaking news in my family chat. Hang on. Oh. Liam Payne. Is this real? Liam Payne dead at 31 after falling from a hotel roof in Buenos Aires? Liam Payne of One Direction? Oh no. Oh no. This just broke while we were on this stream. This just broke at 6:33 p.m. 7 minutes ago. Rest in peace, Liam Payne of One Direction. Oh my God. I wasn't watching the chat. It just came through my family chat. I myself am a One Direction fan. I took my 6-year-old when she wanted to see One Direction. We flew to Buffalo to see One Direction at the stadium where the Bills play because it was cheaper than going to Massachusetts, Madison Square Garden. I'm heartbroken. Yeah, they're saying One Direction singer Liam Payne dies in Argentina after a fall from a balcony. Former One Direction singer, I'm sorry, just to break for a second, I have to read this right now. Died outside a hotel in the Argentine capital, Buenos Aires. Local police confirmed today on Wednesday, saying the 31-year-old British musician was found dead after falling from his 3rd-floor hotel room balcony. In a statement, the Capitol Police said they were called to the hotel in the capital's leafy Palermo neighborhood where they were notified of an aggressive man who could be under the effects of drugs and alcohol. Emergency workers confirmed the death of the singer, who was reportedly found in the hotel's interior patio. Wow. That's heartbreaking. Oh, I'm really sad. Okay, but I'll try and go forward. Okay. All right. And then one of my kids says Liam's Payne. Oh my God, that's so with a broken heart. Oh, okay. They were amazing in concert, by the way. And you guys know I'm a Deadham and I'm a Dave Matthews fan. And I took my 6-year-old to see One Direction and it was amazing. And I've also seen Harry Styles and he's also amazing. Thank you, Justin, for the Cash App as well. All right. That was footnote 3. This kind of pre-mistrial polling is not only permitted under Massachusetts law, it is encouraged. Under Rule of Criminal Procedure 27B, a court intending to declare a mistrial may ask the jury that a jury return verdicts on those charges upon which the jury can agree. The reporter's note to Rule 27B states even more definitively that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. Thus, Massachusetts law expressly enables judges to poll juries ahead of mistrial to determine whether a full or partial mistrial should be declared. Ding, 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 ding. That fact supports appellant's requested evidentiary hearing because such a hearing would achieve the same goal as polling, i.e., for the court and the parties to receive an accurate assessment of the jurors' conclusions without probing the subjective mental processes of jurors, such as the reasons for their decisions. Go to the chat before we start Roman 3. Oh, thank you, Sharon. You've been with me for 11 months. You're an OG. You've been busy today. We love you. I love you guys too. Hello, Zelda Kelly. ACLU, as of September 30th, is demanding the feds investigate Enrique Delgado Garcia's death. Good. I did a show on that last week. And it didn't receive a lot of views. And I would like everyone to go watch it and go share it because I found out a lot of stuff, other cases that happened in other states where recruits were also killed or suffered double amputations because of something called fight night or the big fight. So please watch that stream and share it out because we need to bring more attention to Enrique Delgado Garcia's death. Thank you, Zelda Kelly, for reminding me and for your 5. Girl Ryan says, you got to be willing to dig a little deeper and just do the right thing. Oh, Melanie, not the Commonwealth's strong point. I know, but you can quote me on that. Thank you. Thanks, Girl Ryan. You can make t-shirts. I give you my permission. As long as you give me credit on that quote that I just made up off the top of my head. Roman 3, trial courts also routinely hold post-verdict evidentiary hearings to address irregularities in jury proceedings affecting constitutional rights. The propriety of appellant's requested post-verdict evidentiary hearing is also supported by Massachusetts precedent, which allows for post-verdict evidentiary hearings that inquire into irregularities with jury proceedings that affect constitutional rights, including double jeopardy. The most prominent example of such post-verdict hearings implicates the Sixth Amendment right to an impartial jury. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. Trial courts may conduct a post-verdict evidentiary hearing where evidence suggests that extrinsic influence may have had an impact upon the jury's impartiality. The refusal to do so can itself constitute reversible error, and where the case is close, courts should exercise discretion in favor of conducting a judicial inquiry. Thus, trial courts regularly hold evidentiary hearings to determine whether extraneous influence had an impact on the jury's impartiality. Oh, yes. Oh, yes, they do. Oh, yes, they do. They did it in Murdoch. They did it in Benefield. We're still waiting for the decision on Benefield. They did it in it's a Massachusetts case out of Cape Cod, Krista Worthington. I can't, the name of the defendant escapes me right now, but they called him back in. They called him back in because there was some allegations of racial bias inside the jury room. That was post-verdict. And the refusal to hold a hearing to consider extraneous influence has frequently resulted in reversal on appeal. There's a couple of appellate cases in Massachusetts specifically. Evidentiary hearings have also been held to determine whether a jury's verdict was unanimous as required by Massachusetts Rule of Criminal Procedure 27A and is relevant for purposes of the double jeopardy clause since a prior acquittal or conviction bars a retrial for the same offense. In Commonwealth v. Brown, 1975 case, the jury foreman claimed that the verdict was erroneous, and the trial court held an evidentiary hearing wherein the jury corrected its verdict. On appeal, this court found no impropriety in the trial court's actions. In Commonwealth v. Diaz in 1995, a juror told the trial court that she had not agreed with the verdict. The court interviewed the remaining deliberating jurors, the court officers, the clerk of the court, and any personnel who had knowledge about the rendition of the verdict in this case before declining to disturb the verdict. In the wake of this investigation, this court affirmed the lower court's denial of the defendant's motion for new trial. Additional cases from this and other jurisdictions affirm the ability of courts to conduct such proceedings and take corrective action regarding jury verdicts. To be clear, such inquiries need not reach the content of the jurors' deliberations or the particular reasons for their decisions. There is no obstacle to a trial court taking evidence as to the outcome of the jury's deliberations, given that reporting such information is fundamentally the purpose of the jury. And that is a 2024 case. Oh no, that is the Massachusetts General Evidentiary 606B in 2024. That's a new rule as of 2024? I'm not quite sure. Through such an inquiry, the court can determine the jury's decision, which necessarily bears on whether the robust protections of the double jeopardy clause will apply. Roman 4. The trial court should be compelled to conduct an evidentiary hearing given reports from jurors that the jury agreed appellant was not guilty on counts 1 and 3, such that the court did not have the manifest necessity to declare a full mistrial. In this case, after receiving a third note from the jury indicating difficulty reaching a completely unanimous verdict, the trial court declared a mistrial on all counts and set the stage for a full retrial. But, as appellant's brief cogently describes, her attorneys soon received multiple reports from jurors, in some cases via intermediaries, that the jury had unanimously agreed to acquit on counts 1 and 3. Juror A stated that the jury unanimously agreed to acquit appellant on counts 1 and 3. Juror B believed that every member of the jury, if asked, would confirm that the jury agreed to acquit appellant on counts 1 and 3. Juror D said that every one of us will agree and acknowledge that the jury found appellant guilty. That the jury, back to 1. Juror D said that every one of us will agree and acknowledge that the jury found appellant not guilty of counts 1 and 3. And Juror E confirmed that the jury was unanimous on counts 1 and 3. The Commonwealth also received communications from individual jurors about the jury's agreement on the first and third counts. It is thus unsurprising that the trial court accepted the jurors' statements about this agreement as true and accurate. That's right, she did. And then she ruled against them. Given such overwhelming evidence of the jury's agreement on counts 1 and 3, a post-verdict evidentiary hearing must be ordered to determine whether the jury decided to acquit appellant on any counts such that the trial court did not have manifest necessity to declare a full mistrial. Such a hearing is warranted to assure the sanctity of appellant's right to be free from double jeopardy, a fundamental right, wide in scope, that is deeply ingrained in our legal system. In the area of manifest necessity and mistrial, This court enforces that fundamental right by requiring the careful consideration of alternatives to a mistrial. Given Rule 27B and the nationwide practice of polling juries before mistrials are declared, the trial court could have avoided the instant controversy by polling jurors individually before declaring a mistrial. Unfortunately, it did not, nor does the record reflect that the parties were given an opportunity to request or express their views on whether polling was appropriate. In any event, after the court declared a mistrial on all counts, it promptly received reports that its declaration of a mistrial was premised on an apparent mistake or misunderstanding concerning the jurors' conclusions, i.e., that they were deadlocked on only one count and had actually agreed to acquit appellant on others. At that point, the court not only could have, but should have held an evidentiary hearing to determine whether, in fact, there was manifest necessity for a full mistrial. The court's refusal to do so is reversible error. An evidentiary hearing was and remains necessary because a lack of manifest necessity would mean that retrial on counts 1 and or 3 violates appellant's rights under the double jeopardy clause. Because that clause protects against the burden of enduring multiple trials, not merely the possibility of a conviction upon retrial, a violation of appellant's double jeopardy rights cannot be remedied after a second trial, whether or not she's ever convicted. Citing Green, which stands for the proposition that retrials subjects the defendant to embarrassment, expense, and ordeal, and compels her to live in a continuing state of anxiety and insecurity. Going back to 1896, which states, the prohibition is not against being twice punished, but against being twice put in jeopardy. Put another way, if the trial court lacked manifest necessity for a mistrial on counts 1 and or 3, then appellant's double jeopardy rights will be irredeemably violated even if she is someday acquitted of those charges at a subsequent trial. Thus, a wait and see approach would potentially permit an irreversible violation of the Constitution, and an evidentiary hearing is necessary now. The trial court denied appellant's request for a hearing because it concluded that such a proceeding would impermissibly intrude into the substance of the jury's deliberations. In justifying that ruling, the court said that a hearing would necessarily require the court to understand any supposed tension between the jury's notes to the court and their agreement to acquit the appellant on 2 counts. But that is not so. The trial court is well situated to set appropriate limits on any questioning, and it may only need to ask each juror whether the jury reached a unanimous verdict on count 1 or count 2 or count 3. Mark Betterow and I have been screaming into a closet about this for what feels like forever. As cases like Span make clear, questioning to confirm or understand what the jury decided does not intrude into the deliberative process. In response, the Commonwealth may claim that because post-trial reports from jurors A, B, D, and E were not in front of the trial court when it declared a mistrial, a partial verdict was not a reasonable alternative at the time of the court's declaration, but that argument fails for 2 reasons. First, as appellant observes, the jury's communication with the trial court was susceptible to the interpretation that the only deadlock was related to the lesser included offenses of count 2. So, the trial court had reason to believe that a poll aimed to return a partial verdict was a meaningful alternative to a full mistrial, especially given the existence of Rule 27B. Second, cases like Diaz and Brown demonstrate that post-verdict evidence can support a post-verdict evidentiary hearing into the content of the jury's agreement, even if the evidence was not known to the court ex ante. See Supra Part 3. Thus, the fact that evidence suggesting the jury reach a partial verdict arrived after the trial does not preclude an evidentiary hearing. Just so validated right now, you have no idea. It's just like, it just seems like common sense, right? It just really seems like common sense. I mean, maybe I just have a legal brain, and so to me, I'm single thread, and it just seems like common sense. But to all of you out there who do not have perhaps a legal brain or 30 years experience practicing law in state and federal courts, or didn't go to law school, do you think that this just common sense dictates what's the harm in calling them back and just simply asking them, did you acquit on counts 1 and 3? Because if you did, we really should dismiss those charges, because double jeopardy is really a thing in the United States of America. No, the amicus brief is going to, this is the appellate court. Thank you, witness, for asking. This is in front of the full panel. It's the highest court in Massachusetts, called the SJC, the Supreme Judicial Court, and it will be heard by a panel of, I think, 6 judges. I think 6, 4 or 6. And they are the highest court. They do not hear any evidence. They hear legal argument. If they decide, the appellate court, if the panel decides that it should go back for a hearing, it does go back to the trial judge. So it goes back to Judge Canone, if she's still assigned to the case at that time, which as of right now, she still is. So it would go back to her for the evidentiary hearing, but the appellate court is reading, digesting, analyzing, scrutinizing these briefs prior to the oral argument, which will be on November 6th. And that is when the attorneys will get up and make their arguments in front of the panel of judges, and the judges will and should ask them questions. The timing also supports the use of an evidentiary hearing. As memorialized in attorney affidavits, jurors began raising concerns about the mistrial the day after that declaration was made, and others quickly followed suit. So there is robust, uniform, and contemporaneous evidence of what the jury agreed to. Supported by that evidence, appellant requested an evidentiary hearing within 1 week of the mistrial. Beyond that, the specific nature of this mistrial context lessens the risk of externally influenced post hoc changes, right? This is not a situation where a court would be likely to find an agreement to acquit based on one juror's changing view or post-trial misgivings, both because a significant portion of the jury has already come forward to evidence their agreement, and also because all of the jurors apparently remain available to testify. Yeah, and also, it should be pointed out, no juror has come forward to say that's not true, right? No juror has come forward to say that is not true. That's significant, in my opinion. Almost 400 years ago, the Massachusetts colony enacted the first formal prohibitions against double jeopardy on American soil. In accordance with this tradition, the court should require an evidentiary hearing to ensure that appellant's double jeopardy rights are not violated by a second trial on counts for which the jury already agreed to acquit her, and for which the trial court did not have manifest necessity to declare a mistrial. Such a remedy is necessary to maintain the double jeopardy clause as that strong bulwark of liberty, which stands against the devastating and one-sided nature of the jeopardy that confronts criminal defendants facing retrial. Citing a 2023 case, a Massachusetts case, Martin v. Commonwealth. Conclusion: for the foregoing reasons, this court should vacate the decision of the trial court denying appellant's motion to dismiss and remand for the trial court to conduct an evidentiary hearing if the charges are not otherwise disposed. XOXO. Michael Packard of Quinn Emanuel. Well, that's a major law firm. Major law firm. Nationwide. Big New York and LA offices, represent a lot of celebrities, including somebody, I think, in the Alec Baldwin trial. I think it was Alec Baldwin. All right. Anyway, Quinn Emanuel is a huge firm. They also apparently have a Boston office. It's dated today and signed by Michael Packard. And then also there are some attorneys here with the ACLU, Jesse Rossman, Daniel McFadden. and they are counsel for the amicus curiae, the American Civil Liberties Union of Massachusetts. That Quinn Emanuel is a very, very highly regarded firm. And kudos to them for stepping in, getting it done. Oops, making a difference in this display of shenanigans, tomfoolery, and ballyhoo to which we have been subjected for so long. Let's go to the chat. And also name that movie. No more shenanigans, no more tomfoolery, no more ballyhoo. Grace Face says, it's a beautiful day to be Marty Weinberg. Thank you, Grace Base, for your super chat. Mary Flynn for your super sticker. Phoebe Bird. So if the foreman previously stopped being a police officer because he was hit by a car, would that affect impartiality? It might. But again, we can't really concern ourselves with that right now because there's already a mistrial, right? If there had been a conviction and then it was later found out that a member of the jury may have lied on a verdict on a jury questionnaire, such as in the Ashley Benefield case, where it is alleged that one of the jurors lied and said they had not been a victim of domestic violence or a perpetrator of domestic violence when they clearly were because the rap sheets were provided or the court records, that could overturn the verdict. But here there's a mistrial, so that's kind of, let's not be distracted. Let's keep our eyes on the prize. But I see what you're saying. Thank you so much for your super chat. The ND Fifth, thank you so much for thanking me for my great content. And thank you for tuning in. Romy, hello, Romy. Thank you for the 10. My husband just walked into the room and declared this is all Bev's fault. He didn't even watch the trial, but he's heard from friends and colleagues about the judge. Oh, okay. So you're local, Romy? You're local? Charlene, thanks for hanging with me for 8 months. As Bev's ego is as big as Karen's legal fees. And Cindy says the ACLU is always awesome. Yes. Oh, yes. Oh, yes, they are. Let me make sure that I did not miss anybody here before we go back to the chat. It is a beautiful day to be Marty Weinberg. Really, really, really is. Thank you, Polly, for becoming a new member. All right, see if anybody got the movie first. Good Will Hunting. Yes, it is, Charlene. We the first? I don't know. I'm scrolling backwards now. Good Will Hunting is a JMac. You are correct. You know, that's a Boston movie. Sidney Collin. Yes, it is. You guys knew it. You guys knew it. Or did you guys, because I let it out, I think, I don't know, during Joe Flip Ahead knew. Oh, thank you, Mama She, for your very kind cash app. Says thank you for a very busy day. Thank you guys for hanging in there with me. This is my third stream of the day. Thank you, Blessed Mom from Texas, for being late. And the replay is always good too. Okay. Charlene says, I know how huge this feels personally, but how big is this? In my opinion, when a third party such as like the ACLU steps in with the goods, like they don't have a personal stake in this case other than protecting the civil liberties of the citizens of the United States of America. I think it's big. Ask 5 lawyers and you'll get 5 different opinions. I think it's a big deal. I think it's a really big deal. It's Quinn Emanuel. All kinds of monkey business and shenanigans, says Joseph. Hi, Peter Murphy says the feds need to come in. Been saying that for a long time. That's a great question, Britt Gal. Who will brief the appellate court? Lally or Brennan or someone else completely? I don't know. Let's see whose name is on the brief. The brief was due today, so if it hasn't hit the docket yet, maybe they just didn't. Maybe they just didn't, log it in yet. That's a possibility. I don't know. I don't know that Brennan is an appellate attorney. I don't know that he's argued in front of the appellate courts. It's a specialty. It is definitely a specialty. Martin thinks Karen would get a more fair trial in North Korea. It's crazy, right? Crazy. Oh, Fem Dandy, what happened? You getting bullied in the true crime community? It's terrible. We love everyone here. I'm sorry for you. I'm sorry that look, there's a lot of really hateful people out there. Most of them are on Twitter, so that's why I don't go there. So just you're safe here. Hang out here. Hang out with us. We love you. Let's see. Deanna, didn't Auntie Bev tell the jurors they had to have a verdict on all charges before they said anything? Absolutely. You must be unanimous on each count before you report back. That's exactly what it was. Thank you, Perry, for the Venmo. Says, thanks for your coverage. Loading. Do you think Bev will have any repercussions? Love your earrings, Dave Matthews. Thank you. Rock and Roll Hall of Fame. Here we come. Repercussions? No. I mean, judicial discretion. They have judicial discretion. So, she was within her discretion. But, sometimes you got to think you also have the discretion to poll the jury. You also have the discretion to hold an evidentiary hearing. How about do the right thing. Just do the right thing. It's not hard. Thank you, little cupcake. In order to receive notifications when I go live, hit the subscribe button. Today I went live twice, like spur of the moment, because we covered that Menendez brothers hearing press conference in LA, right outside the downtown LA courthouse. Thank you, Sherilyn, so much for the cash app. And we covered the Robert Tellis sentencing this morning, and then we covered this. I wasn't expecting this. So these were all very last minute. And you might not get a notification until it's too late. So you want to have that bell set, and you want to have your phone set to accept notifications from YouTube. What up? What up? Says Karen was not drunk. John would not let her drive if she was drunk. Everyone said she wasn't drunk. She wasn't charged with drinking and driving. She did not have a breathalyzer. It's all BS. Thank you. I think we need a sidebar too. Warrior River. Laura says, I'm sorry, but there is no way the alternates were randomly selected. The A team is getting new members, says PU. Seems that way. Chantal says it's her favorite channel in chat. Thank you. Oh, you're an OG too, 11 months. I've only had members, I think, for exactly 1 year. So thank you. And Shelly, thanks for always jumping in to explain these filings and for your insight. I still can't believe this is real life. I can't either. We are outraged. We are outraged. This could be any one of you. This could be any one of you. This is frightening and horrifying and tragic. And the world is watching. What the duck? For those of you who don't know, they are prosecuting a man in Canton for distributing little rubber duckies with stickers on the bottom that said Colin did it and IYKYK. They are charging him with felony witness intimidation and littering. He also had some monopoly money that he took a hand stamper and stamped Colin did it. He is facing multiple felony charges for hurting the feelings of one of the witnesses in this case. This is I did a stream on this. It's called What the Duck or something. It's got a big rubber ducky on the thumbnail. They wrote a 36-page police report. They did more of an investigation into the rubber ducky scandal than they did into the investigation of the murder of Officer John O'Keefe. And that should horrify every single one of you. They went to this man's home. They did a trash pull. They went through his garbage. They filed subpoenas to makestickers.com to get all of the proof that he had ordered these stickers from that company to terrorize these witnesses with his little rubber duckies that children apparently enjoyed finding in and around Canton. They filed subpoenas with makestickers.com and I'm promoting them because Adam, their owner, would not give up any information on the order history of Richard Schiffer without a subpoena, without a warrant. They went and got a warrant to download the telematics infotainment system from his car so they could show where he was if he was anywhere near where these rubber ducks were. It's mind-numbing at the highest levels. I mean, you can't even make this up. You can't even make it up. Gibbons, Laura Jean says, welcome to Massachusetts. This kind of stuff is going down in every town here. Thank you. Thank you. Even my mics are hot. Says, please donate to Rich's defense fund. IYKYK. Rich Schiffer is the gentleman. He's in his 60s. He said, I was kind of bored sitting around smoking a joint one night. I'm like, what can I do to help the cause? I don't know. I'll order some rubber duckies and put some stickers on them. I mean, like literally, he's done interviews. He seems like a very nice man. What are we doing? What are you doing up there in Massachusetts? I don't live there. It does seem extreme. It's total embarrassment, says Laura. Crazy. Glamma duck. Look at that. Look at the little rubber ducky profile pic. Glamma duck. We had I think grandma duck in here earlier, but everyone, I love when you guys do this. What bizarro world have we? What bizarro law world have we dropped in? This is like it's like something on, like The Handmaid's Tale. It's post-apocalyptic. I mean, I don't know any other way to describe it. It's insane. No, Paul O'Keefe civil court would not be double jeopardy because it's not a criminal case. Double jeopardy only applies to criminal cases. So no, apples and oranges, double jeopardy does not apply. But Karen Reed still should be able to get a stay in the civil case because her right to plead the fifth is an actual right. And the argument that that case should not be stayed because she should be forced to testify in that case before her criminal case because she chose to speak to news outlets is weak. It's a weak argument. The Fifth Amendment is an actual right. So there's that. We are true crime. Brian's ramblings, they act like no one's watching, says Allison Meeker. And that is so very true. Thank you, my friends, for hanging around with me for 3 streams today. Please go back, smash the like button on each of them, share them out. It helps the channel. Help me in my personal quest, please, to beat Vinnie Politan in subscribers on YouTube. Did you notice lately, he's got a private YouTube channel, but lately they've been co-streaming his private channel on the Court TV channel. I don't know if they lost a lot of subs at Court TV because of all these crazy things that are going on and the crazy people that they've been having on as experts and the crazy people that they've had covering this case. It's crazy. And I have a personal quest to beat Vinnie Politan in subscribers. And right now I'm at 69.7 thousand. And so if you just hit that subscribe button, like it's free, it would really help. Also smash the like because that helps the algorithm. There's some weird algorithm on YouTube. I have 69.7 and I don't know what he's got. Let's just check. We'll do a check. And we're looking at his private channel. He doesn't know anything about this competition, by the way. He's at 80K. I'm like 10,000 behind. At one point we were getting close. We were at about like 7,000 apart. Thanks, Andrea, who says, we are warriors. We are warriors. These are my true crime people here in this chat. Hubby is snoring next to me. And I'm like, how loud are you trying to be? Thank you, Turd Ferguson, for gifting 5 memberships. And for those of you who were gifted, today's your lucky day. Go out and buy a lottery ticket because, things can only get better, right? Things can only get better, you guys. The full moon is coming, just so you know. The full moon is coming. It's tomorrow. Okay. So it's going to be like a blood moon. It's like the 4th supermoon of the year. Glare told me he didn't really care about it and he ignored me last night when I tried to talk about it. So this is my channel and now I'm going to talk about whatever I want, damn it. And I will not be ignored, Will. I will not be ignored. Thank you so much for tuning in today. Thank you, my moderators, for coming in here 3 times today. You are truly the greatest moderators on YouTube. You are the greatest chat on YouTube. You are Melissa? Wait, Melissa, are you the Melissa that wrote my theme song? Turd Ferguson, Melissa who wrote the theme song? Did you see I made a little video about it? I gave you credit. I'm gonna put your name in the credits there if you want me to. I mean, I'm gonna anyway, but I want to know how you want to be credited. So can you shoot me an email and let me know how you want to be credited for my new theme song, which is amazing. Thank you, Turd Ferguson. We love you. Do you guys like the theme song? It's amazing, right? Somebody say, I acknowledge and enjoy acknowledging and talking to the full moon. Yeah, it is. It's a real, the energy is real. The energy is real. Oh, J Max says, I'm the greatest YouTuber. Thank you. We are the troopers. You guys, I also did a crazy story about a woman in Kentucky who chopped up her mom and cooked her in the oven and also was casting spells on people. Watch it. It's crazy. Her name is Toralina May Fields, 32. It's a crazy story. It's a short stream. Go back and watch it. I'll be following that closely. In addition to the other crazy Kentucky story with the sheriff who killed the judge. We still don't know what that's up about. What that's about. Witness. Thank you. Love to our mental health care workers. Full moon. Take care. Be safe. Yep. All of you. Be safe. Who knows what I'll do tomorrow? I don't know. I was going to go to court today with the Long Island serial killer, but I just, with all these things popping up, I'm glad I didn't because it was kind of a nothing today. Nothing really happened. And the one time or the two times that I went to court for the Long Island serial killer, Rex Sherman, he's the accused Long Island serial killer. The one time that I went there, I was sitting in the third row. He turned around, he looked me right in the eyes. And it was chilling. I have been stared down by a serial killer, and I don't know a lot of people that can say that. I know, Angela, R.I.P. Liam Payne. I'm devastated about this too. I've been trying to not. I will process it as soon as I get off here. But yeah, Angela's going to continue crying and listening to 1D. And my family chat said, Diddy did it. Diddy did it. Who knows? What a sad. I need to learn more about this Liam Payne death. So, oh yes, oh yes, oh yes. Thank you so much. And just continue to be your cool, kind, and classy selves because you are helping to make the world a better place. Destiny, I would love to see you team up with Lawyer Thanks, Rod. Thank you so much. He doesn't really co-stream much, does he? I would love to. I mean, if anybody knows Peter or is a mod for Peter, certainly let him know. I'm totally open to it. Tomorrow night, I think it's tomorrow night. We've tried to plan this 5 times. But I spoke to Allie today and Bob, and I should be going on Defense Diaries tomorrow night to do a primer on the Delphi case. There's some crazy stuff happening there. Bob Mata is physically in Delphi, as is Andrea Burkhart. And I heard Lawyer Lee is also there. And there are no cameras in the courtrooms. There is no live tweeting from the courthouse. So I think Allie and I are going to team up for our ladies lawyer live or ladies who lawyer. I don't know what we call ourselves, but I love Allie Mata, and I know you guys do too. And thank you, Sidebot and Grill, for coming in with 5 memberships right at the very end. It's hard for me to stop talking because I love you guys so much. Do all the YouTubeish type things that YouTube loves and just keep being your kind, cool, and classy selves, and you're making the world and YouTube a better place, you guys. I promise you, you really, really are. Thank you. And rest in peace, Liam Payne. Peace.